DeWaal here, and this is Bridging the Week for November 2nd to 6th, and today is November 9th, 2015. Good morning. Resolution of criminal actions, including jury verdicts and pleas, highlighted developments in the financial services industry last week. Among these actions, not only was Michael Coscia convicted in a widely followed case involving the new Dodd-Frank provision of law prohibiting spoofing, but two former employees of the New York Federal Reserve Bank also pled guilty to criminal charges in connection with leaks of non-public information. Meanwhile, the Securities and Exchange Commission's Director of Enforcement endeavored to calm chief compliance officers that the agency was not out to get them, despite a number of recent SEC enforcement actions against CCOs of investment advisors. We have a lot to cover this week, so let's get started. After a 7-day trial, Michael Coscia was convicted last week of 6 counts of commodities fraud and 6 counts of spoofing in connection with his trading activities on CME Group exchanges and ICE Futures Europe from August through October 2011. Mr. Coscia had initially been indicted for such offenses in October 2014. According to Mr. Coscia's indictment, during the relevant time, he utilized 2 computer-driven algorithmic trading programs that repeatedly placed small buy-or-sell orders in a market, followed by the rapid placement and retraction of large orders, so-called quote orders, on the opposite side of his small orders. He supposedly did this in order to deceive the market and help ensure the execution of his small orders at favorable prices. After the initial small orders were executed, Mr. Coscia would reverse the process, placing new small orders on the opposite side of the market as his initial filled orders, and large quote orders on the opposite side of the new small orders. Mr. Coscia allegedly traded this way in order to ensure the fills of the new small orders and profits on the overall transaction. This case marked the first indictment and conviction under the new anti-spoofing provision of the relevant law that was added as part of the Dodd-Frank Wall Street Reform and Consumer Protection Act in 2010. Sentencing is scheduled to occur on March 17, 2016. Mr. Coscia could face 25 years in prison for each count of commodities fraud and 10 years in prison for each count of spoofing. Given the disconnect between the plain language of the statutory prohibition against spoofing and long-time acceptable practice in the trade, this verdict may have a chilling impact, if not more, on trading activity. I have written something on this on the article version of Bridging the Week on the website. Check it out. Anthony Allen and Anthony Conti, residents of England, were found guilty of manipulating the London Interbank offered rates for US dollar and yen benchmark interest rates at various times between mid-2005 and 2011. Both individuals were previously traders for Rabobank. In October 2013, Rabobank itself entered into a deferred prosecution agreement with the U.S. Department of Justice and agreed to pay sanctions of $325 million US, and also settled civil charges with the Commodity Futures Trading Commission and the UK Financial Conduct Authority for violations related to its LIBOR submissions. Separately, as expected, Rohit Bansal, a former employee of Goldman Sachs & Co. and the New York Federal Reserve Bank, and Jason Gross, a former employee of the New York Fed only, pled guilty to charges related to the unauthorized use of non-public confidential information by Mr. Bansal while employed by Goldman, which he obtained from Mr. Gross. And finally, Michael Oppenheim, a former employee of JP Morgan Securities, pled guilty to embezzlement and securities fraud in connection with his theft of $22 million US from investors over a 7-year period. According to the U.S. Attorney's Office in Manhattan, Mr. Gross told his clients he would invest their money in low-risk municipal bonds and sent them fake account statements while using their funds for his personal purposes. All of the defendants are scheduled for sentencing at various times in early 2016. Andrew Karesny, director of the Division of Enforcement of the Securities and Exchange Commission, said in a speech last week before a group of compliance professionals that concern over recent SEC enforcement actions against chief compliance officers of investment advisors is misplaced. He claimed that the actions, quote, punish misconduct that falls outside the bounds of the work that nearly all of you do on a daily basis, do not involve the exercise of good faith judgments, and are consistent with the partnership we have developed to foster compliance with the laws, end of quote. According to Mr. Koresny, the SEC has traditionally brought only 3 types of cases against CCOs, where CCOs are affirmatively involved in misconduct unrelated to their compliance function, where CCOs obstruct or mislead commission staff, and where the CCO has exhibited a wholesale failure to carry out his or her responsibilities, end of quote. He acknowledged that it was this latter category of cases that has recently engendered criticisms, including from former Commissioner Daniel Gallagher and current Commissioner Louis Aguiar, in connection with actions against CCOs of certain investment advisors. However, Mr. Koresny insisted that these type of cases were far and few between. For example, only 5 enforcement actions against individuals with the title of CCO in the past 12 years, and were justified by egregious facts. Whether Mr. Koresny's comments are enough to calm CCOs, maybe not. I tell my views on the article version of Bridging the Week on the website. Check it out. And finally, CME Group Business Conduct Committees authorized the filing and settlement of a number of actions involving violations of prohibitions against disruptive practices and exchange requirements regarding exchange for physicals and position limits. In 2 actions, Chicago Board of Trade Business Conduct Committees fined Matthew Garber, an exchange member, $60,000 in total for engaging in layering type activity involving larger size orders of soybean futures contracts to effectuate small size orders on the opposite side of the market, and for entering orders in various agricultural futures during Globex pre-open sessions, quote, that were not made in good faith for the purpose of executing bona fide transactions, end of quote. Mr. Garber agreed to fines to settle these matters, as well as suspension from trading CME Group products for 35 days, spread over 2 time periods. Separately, Michigan Agricultural Commodities, Inc., a non-member, agreed to pay a fine of $30,000 to resolve charges that it entered to 8 purported EFP transactions between September 2012 and September 2013 without transferring a physical position. Finally, Quadra Commodities, a non-member, agreed to pay a fine of $40,000 for holding positions in excess of spot month position limits in soybeans on June 27 and 28, 2013, and for endeavoring to resolve its position limit issues through EFPs, 2 of which were non-bona fide for lacking proper documentation. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, have a great week. This is Gary DeWaal. Ciao.